This is Democracy,
a podcast about the people of the United States.
A podcast about citizenship.
About engaging with politics and the world around you.
A podcast about educating yourself on today's important issues
and how to have a voice in what happens next.
Hello and welcome to our latest episode of This is Democracy. I'm Zachary and Jeremi. Today we're going to be discussing an issue that I think many of us have thought about in vague terms in the last few years as we watch our politics in so many ways descend into what cannot be described as anything but chaos, but one that we probably have not thought of in such detail and with such thoughtfulness as our next guest. Our guest today is Professor Steven Skowronek. Professor Skowronek is the Pelatiah Perit Professor of Political and Social Science at Yale University. In 2019, he was the Wynan Visiting Professor at the Rothermere American Institute at Balliol College, Oxford. He's also been a fellow at the Woodrow Wilson International Center for Scholars, and he has held the chair in American Civilization at the École des Hautes Études et Sciences Sociales in Paris. His most recent book, which we'll be discussing today, is The Adaptability Paradox, Political Inclusion and Constitutional Resilience. Other publications of his include Phantoms of a Beleaguered Republic, The Policy State, and many other books. His research concerns, first and foremost, American national institutions and American political development, which is what we'll be discussing today, specifically the development of the American Constitution. We're also joined, of course, by Professor Jeremi. Good morning to both of you.
Good morning, Zachary.
Wonderful. Well, I'd like to start our episode off today with a passage from Hamilton's Federalist Paper 85 on the topic of perfection in the Constitution. The system, though it may not be perfect in every part, is upon the whole a good one, is the best that the present views and circumstances of the country will permit, and is such and one as promises every species of security which a reasonable people can desire. I answer in the next place that I should esteem it the extreme of imprudence to prolong the precarious state of our national affairs and to expose the Union to the jeopardy of successive experiments in the chimerical pursuit of a perfect plan. I never expect to see a perfect work from imperfect man. The result of the deliberations of all collective bodies must necessarily be a compound, as well of the errors and prejudices as of the good sense and wisdom of the individuals of whom they are composed. The compacts which are to embrace 13 distinct states in a common bond of amity and union must as necessarily be a compromise of as many dissimilar interests and inclinations. How can perfection spring from such materials? Well, with that as food for thought, I want to start by asking Professor Skowronek, how did the framers think of constitutional amendment and adaptability? Do you think they expected we would still be operating off the same document?
Yeah, well, thanks for having me first. I don't think that they thought that it would last for 230 years without some major rethinking. They did provide for amendment, but amendments themselves change bits and pieces. Amendments themselves are a method of adaptation. So I don't. They didn't provide. Well, I guess they did with different methods of calling constitutional conventions, but I don't think that they anticipated that we would just keep tweaking the thing forever.
That makes sense.
Jefferson famously was skeptical of adaptation. He didn't think that you should read powers or arrangements into the Constitution that aren't clearly stated. He says, let's not make it blank paper by construction, by continual interpretation. Interestingly, John Marshall had a different view. He says that the Constitution was meant to endure for decades of time and to be adapted to the crises of human affairs. He said that, however, in an early case dealing with congressional authority to create a national bank. And what's interesting about that case to me is that it didn't produce consensus on an adaptation. In fact, it divided the political class in two. And, in a couple of years, Andrew Jackson dismantled that bank despite Marshall's claim that the authority was in the Constitution. So I think that adaptation has been a complicated issue and becomes more complicated over time.
I wanted to ask, the title of your book is The Adaptability Paradox, and we'll obviously get to the paradox part of that conversation very soon. But what about the first part, adaptability? What does it mean for a constitution to be adaptable in this context?
Well, so what is an adaptation? An adaptation is a changing parts of a system while carrying other parts forward and modifying several of those parts that are carried forward to work in conjunction with the new. So it's a continual tweaking of a set of arrangements. If you think about the Constitution as a holistic set of institutions, a system of institutions, and you think about continually jettisoning some assumptions in that system, adding some new things in. The question is, how long can you keep doing that and still have the structure itself make some sense and have some coherent integrity and essential purpose?
Steve, one of the points you make from very beginning of the book is that the Constitution, this is your chapter in particular on bounded resilience, that the Constitution was built around limiting those who participated in it, and through limiting the participants, it actually made it easier to form consensus. And at some level, that putting together, keeping a consensus together seems crucial for you. Yeah. Why is that so? Why wouldn't the opposite argument, the one that I think I've often made, be true, which is the way I think of Madison's argument on pluralism, that being large and being unbounded means that, as we did throughout the 19th century, you can add two new territories, one for one side, one Democratic territory, one Whig or Republican territory. Why isn't the unbounding actually an advantage?
Well, Madison has two thoughts. One is the extended republic. That is, expanding the field of representation makes all interests safer. So it prevents the formation of tyrannical majorities. But if you look at Federalist 51, he also mentions a practicable sphere of self-government. So I don't think that he thought it was limitless. I don't think he thought that this extension, he was thinking of geographical extensions, but think about extensions of democracy itself, of the inclusion of previously excluded groups. I don't think that the Constitution contemplated that as a limitless process. I think they thought, at least for the arrangements that they were setting up, that there was a practicable sphere of expansion. And as it turns out, just empirically, those practicable spheres were always premised on keeping some interests out, excluding some interests. And the interests that were excluded at the beginning were quite extensive. Right. They included wide swaths of the population, not just slaves, but women, things that were excluded, work relations, gender relations, family relations, all of which worked according to other sets of rules. And the slavery exclusion was conscious, but these other exclusions were just assumptions about politics at the time. So I think that the Constitution has, famously abstract language. It doesn't recognize privileges of rank, but it was designed for the people who framed it. It was designed for the notables. It was designed by the notables of the 18th century around their assumptions of who was going to be running the show, right? And I do think that the Constitution's general language, its abstract language, opened the door to challenges from those who were excluded, and that's how you get the democratization of the polity over time, and the Constitution and elites trying to adapt the Constitution to that expansion of the relevant polity. But, I come back to Federalist 51, where Madison says, that you have to think, what is the practicable sphere? The practicable sphere.
That makes sense. What about the second part of the title of your book, the paradox part? What in sort of simple terms is the adaptability paradox that you see at the center of our constitutional development?
The Constitution's most radical principle is its democratic principle, the sovereignty of the people. And as the people become the people who are included within the privileges, access to the privileges of the Constitution and the security of the Constitution, as that expands, every time it expands in a major way, we reconfigure the Constitution, we adapt it, we reorganize it, we rearrange it, we rewire it. The paradox is that once we, the people, becomes fully inclusive, which I would date to around the rights revolution of the 60s and 70s, once we, the people, becomes fully inclusive, then the Constitution seems to be losing its capacity to reestablish firm footings and to stabilize the polity. Once, for successive rounds of inclusion, we were able to reconfigure constitutional relationships and stabilize the polity. But since the rights revolution, we haven't been able to agree on terms for accommodating all the players now in the fold. The paradox is that once we the people becomes a reality, the Constitution loses its capacity to provide firm footings and stabilize the polity.
That makes sense. You argue in the preface to your book that there are, quote, tensions inherent in the term constitutional democracy. Why is it that the sort of growth of the democracy end of that equation, as you see it, destabilized the system or led to this instability?
Well, scholars and American thinkers have noticed this tension between constitutionalism and democracy from the very beginning. I mean, Jefferson says, you can't keep it, you don't adapt it, have a constitutional convention every generation and reconfigure it. Don't just keep reinterpreting it. In the 20th century, John Dewey says, the arrangements that we set up to stabilize a particular polity create conditions for development that make that create a new polity that is incompatible with those institutions. So again, constitutional democracy is expanding under arrangements that then call those arrangements into question, call that Constitution into question. So Dewey says, that the hardest thing for a democracy is to break through the arrangements that were provided for it, but then no longer suit it. And it's dangerous because it's hard to break through, overturn those institutions democratically. And then later in the 20th century, you get Sheldon Wolin, who tells us that democracy is inherently transgressive. It's inherently challenging the constraints and structures that define what a constitution is, which is a system of constraints, a structure of constraints, that democracy is constantly challenging those constraints, and that constitutions are inherently regimes that a particular set of democratic participants agrees will secure their interests, then that democracy, in a kind of dialectical fashion, outgrows those arrangements and needs to challenge them and constrain them. So you get this constant that is the tension in this compound constitutional democracy. How can you get the security and protection that constitutions promise in democracies which are inherently transgressive and constantly challenging the constraints?
Jeremy?
So I especially reading the latter half of your book, Steve, you make a compelling case that you just started to make that we've outgrown the design and the architecture of our Constitution as it is, and you seem to lean toward building, as you say, a civic and conversation, a dialogue, an educated Deweyite set of discussions that would lead to some sort of new constitution, some sort of formal or informal constitutional convention. First of all, are you confident that could happen? But the secondary question is that the right way to go, or maybe the era of constitutional democracies has passed, right? I mean, there are many democracies, the English one, of course, that operate without a constitution and have operated reasonably successfully. So is it worth going that route, or is it worth finding an alternative to a constitution at all?
So this isn't a happy book. This is it's a book that tries to just examine certain dynamics that run through American history and see where they've landed us. And I think they've landed us in a pretty tight spot. So, and I think what you say is exactly right. It might be time to open a question as to whether this Constitution is serviceable for the democracy that we have become. I think that the Constitution was, as I said, framed for the notables of the 18th century, and the principles that we hold up, checks and balances, separation of powers, federalism, all of these things were designed to secure the participants of that time and also to keep other issues out. And the intrusion of those other issues, in particular, since the rights revolution, issues of social justice were issues that the Constitution was intended to submerge and that it seems to be very ill-equipped to address. Now, my solution or my ideal system, I don't really describe anything like this in the book, but I do say that the objective would be a strong constitution that can service a fully inclusive polity, and that we don't have that. We don't have a strong constitution that's effectively services a fully inclusive polity. That's, I think, what would be the ideal circumstance. I think you do want the protections of a democracy, of a constitution, the legal protections. I think we see right now the vulnerability of the protections that we were promised. So I'm not willing to give up on constitutionalism. The question is, can we get a strong constitution that effectively services a fully inclusive polity? And my contention is that we do not have that now.
If I could follow up quickly, Steve, a historical question. As I was reading your book and thinking about what you just said, which I think follows beautifully from your argument, I started to think, well, maybe this was actually an oversight by Lincoln. Because if there was a moment when there might have been a political entity that could have done what you just said, it might have been the Republican Party, in 1865, 1866?
Yeah, well, the one of the problems with Reconstruction was that the radical Republicans were, or I should say, the Republican Party was committed to adaptation. Right? They didn't see that, in fact, the emancipation and the challenge to federalism threw the entire system into question. And jerry-rigging arrangements, could work for a time, could stabilize the system again. In fact, it did work for another century. But that ultimately, the logic of gutting federalism, which is, I think, the constitutional implication of the civil rights movement, is that it throws up all the contending principles of the Constitution of 1787, throws them all up for grabs. The contending purposes of the original Constitution, the sovereignty of the people and federalism, the tensions, all of those tensions are released once the last exclusions are lifted. And so I do think that the Republican Party, as noble as its cause was, thought that they could still make it work. They could still tweak it, right? The 14th Amendment, the 15th Amendment, they could still make it work. And I guess I'm wondering whether that's the case.
I'm wondering, when you think of the places where it's not working today, what are the sort of institutions in particular that you would point to as indicative of a sort of inability for the Constitution to stabilize?
Well, So let's take three. So one is this new juristocracy, our increasing dependence on the Supreme Court to determine what the appropriate boundaries are. Now, we would think, oh, well, that's just the Constitution's solution to how you settle boundary disputes. You give it to the court. But in fact, as I mentioned with the John Marshall example, authorizing a national bank, the judges have a very spotty record of settling boundary disputes when there's no consensus on the underlying purposes. And we have no consensus on the underlying purposes, and we're increasingly dependent on the court. And I'm not blaming the Roberts Court. This began with the Warren Court.
Right.
The American juristocracy arose alongside the rights revolution. Let me take another example, what constitutional law scholars call hardball. That is the doubling down on constitutional provisions that were meant to provide security and to foster buy-in from contending interests. Constitutional hardball is now using constitutional provisions to sabotage the system. So we get, the routinization of impeachment. We get Second Amendment absolutism. We get gerrymandering wars, government shutdowns, debt ceiling brinkmanship. All of this is not rewiring the Constitution. All of that can be justified by constitutional principles, but that's not rewiring the Constitution. That's the Constitution going haywire. That's using its provisions as weapons of sabotage. And I'll end with a final example, which is, the one closest to my other work, which is the rise of presidentialism, which the court is implicit with this immunity decision, that, the president stands at this critical intersection between national political mobilization and national administrative management. And what we've done on the mobilization side is to, along with the rights revolution, create these personal parties where the president controls his own political machinery. And on the management side, we've created this unitary theory of the executive, which gives the president a claim to exclusive and complete control over the power of the administrative branch, of the executive branch. And that is not a formula for rewiring. That's a formula for imposition. That's a formula for volatility and divisiveness. Interestingly, the framers of the Constitution, what was their formula for the presidency? Their formula was management without mobilization. They sought to make the selection of the president indirect and blind. To give him the executive power was coupled with keeping him away from party interest and faction, because they saw that a politicized president in control of the executive branch would undercut all the delicate balances that they had written into the rest of the constitutional frame. So I would say at least those are the three that come to mind: juristocracy, presidentialism, constitutional hardball. These are things that are showing us that it's not working. It's not by what do I mean by working? It's not accommodating interests. It's not stabilizing the system, the things that we assume that that constitutions are meant to do.
Steve, I wanted to ask you a question that connects your analysis to some of the contemporary debates. You do this again toward the end of the book. Individuals like my own governor in Texas, Greg Abbott, have called for a constitutional convention. And of course, many states, especially after the Civil War, had constitutional conventions to rewrite their constitutions. Are you in favor of that now? Or how do you think we should move forward now after reading your book, if we're persuaded by your argument?
Right. Well, I would say that in writing this book, I became more sympathetic to Jefferson's solution. That is, rethink the whole thing every generation or so. But also in rewriting the book, I came to appreciate that we've really dug ourselves pretty deeply into this hole. That in order to have a constitutional convention, think about the original constitutional convention, where, contentious interests, diametrically opposed interests came together around some sense of a common purpose. That is, the North and the South were able to subordinate their differences, to exclude certain questions, to participate in this kind of deeply impacted institutional system because they had in mind the promise of a great commercial republic. They could agree on that. We want this we see the potential for what this could be, and we're going to figure out how to realize that potential while avoiding our fundamental disputes. I just don't see that there's any agreement on fundamental purposes at the moment. And that, I think, makes a constitutional convention a dubious proposition. It will become just another mechanism for imposition. Or it'll just deadlock.
Right. So what should we do, Steve?
What should we do?
Yeah.
Well, right. That's the big question. I don't have a prescription, but I do think that what I try to suggest at the end of the book is that to create conditions on which we might be able to even discuss what an alternative governing framework might look like. And, those are long-term propositions. I'm not sure we have a lot of time, but those are long-term propositions. I would give them a shot. Things like experiments with deliberative democracy, I think that those are deliberative forums, or, those kinds of things I think are constructive. I'm in favor of this revival of interest in civics and civic education, although I think also symptomatic of the time is that no one can really agree on what the curriculum is. So what should we do? I think we should try to find some alternative means of communication and deliberation outside the constitutional structure that will allow us to think about what kind of government we want.
Well, thank you so much, Professor Skowronek, for joining us today. We encourage all of our listeners to go and read Professor Skowronek's new book. That is The Adaptability Paradox, Political Inclusion and Constitutional Resilience, out just now from the University of Chicago Press. So please go read that, buy the book. And thank you to Professor Skowronek for joining us on this episode of This is Democracy. And thank you as well to Professor Suri.
Thanks for having me.
Thank you.
And thank you most of all to our wonderful listeners for joining us for this episode of This is Democracy.
This podcast is produced by the Liberal Arts ITS Development Studio
and the College of Liberal Arts at the University of Texas at Austin.
The music in this episode was written and recorded by Scott Holmes.
Stay tuned for a new episode every week.
You can find This is Democracy on Apple Podcasts, Spotify, and YouTube.
See you next time.